Let's take a look at a professional responsibility question from the February 2014 bar. It's question 1. Now, the first thing I want you to recognize about this question is that, of course, it's focused on the duties of the prosecutor. Now, in focusing on these duties, I think what's very interesting about this question is it's asking you to pick apart the kinds of facts that can be discussed in a press release versus the kinds of facts that can't, or statements that can't. It also wants you to look at a specific timeline of information that was available to the prosecutor to determine whether or not there was probable cause throughout the proceeding, from the charge all the way through. The problem also deals with basically false statements or lies before the court, exculpatory evidence. Importantly, the issue of whether or not the exculpatory evidence was material. That made a difference here. And then communication with the judge outside of counsel, probably for an improper purpose. So let's kind of proceed through the analysis in a step-by-step way. I want you to also pay attention. There's 2 different ways that you can set up a professional responsibility answer, and you can start with what happened, meaning the facts, okay? Or you can start with the duties themselves. And depending on which answer you look at from which different bar exam, you'll see that either of those approaches can work. Myself, I like this approach because it's saying, okay, look, we had a press release, we had a probable cause issue, we had, this is what I would prefer myself. So let's move through it. What happened in this case? We had a guy who was arrested for burglary on the basis of a forensic investigation that later turned out to be maybe not as reliable, but there were some eyewitnesses that turned up to sort of bolster the case, and the prosecutor moved forward anyway, saying to the court that they could move forward. I'm going to have to erase this whole thing, but I'm just going to keep going. So with the press release, the basic rule with press release has to do with the prosecutor's main duty, which is 2 sides. Whereas a defense counsel, or even a plaintiff's counsel, they have to zealously represent their client alone, the prosecutor really has a dual duty. The duty to prosecute the potentially guilty, but also to protect the innocent. And that has to do with what they're able to say and also the kind of evidence they have to reveal. So with a press release, here's what can happen. The prosecutor is allowed to make general statements of fact. Like here it says Dave was arrested for burglary. That's not a problem. And you can say, okay, Dave was transient. That's not a problem. But the prosecutor cannot make prejudicial statements. And the idea here is that you cannot make statements that would create a substantial likelihood of material prejudice. What does that mean? It means it's going to make it likely that the average person who's probably, the average juror is going to think differently about the case based on the statement they heard outside court versus the statements they hear inside court. That's what that means. And so you can't do that because why? The person needs to be convicted beyond a reasonable doubt in court, not because of things happening outside the court. So you cannot make statements that are going to prejudice the case outside of court. So here, why do we care about all that? Because this entire analysis was all about, do you understand the rule so that you can say, okay, well, when the police officer made these 2 factual statements, that wasn't a problem. But when the police officer said, you know what, I have this inspector, Ng, I believe it was, who has a known ability to apprehend the guilty, was that a prejudicial statement? There's arguments all around that. First of all, does the prosecutor have a duty to police the police? Does he have a duty to deal with that? And the answer is yeah. If the prosecutor has a reasonable opportunity to sort of abide by these rules and to look over what the police are doing, yes, the prosecutor has a duty. Now, these facts can come in, but the prejudicial statement about this investigator, was it really a prejudicial statement that people found out this guy is really good at finding criminals? Was there a statement? Not really. It wasn't a statement. It was just a fact. But the problem is that that particular fact coming into the public tends to suggest that this person is guilty, and therefore it's a prejudicial statement that could have a substantial effect on the outcome of the case. That's essentially this whole analysis. Can you distinguish between what's allowed to be said and what's not allowed to be said? So read the answer and try to get that clear in your mind. Prosecution without probable cause. The prosecutor has to have probable cause to charge and has to proceed through the entire case in good faith. Now, in the answer that you'll see, it focuses on probable cause. It doesn't say good faith, but good faith is part of the prosecutorial duty. So in the timeline, now you want to kind of sequence your answer and you say, okay, well, initially, based on a forensic investigation, there was probable cause, no problem. But then it turns out that there was an agency report, a federal agency report, that invalidated this forensic investigation. Well, that's a problem, especially because that federal agency report came out right before the attorney went to the judge and said, yeah, I'm ready to go. So what should have happened here? And read the answer. What should have happened is as soon as the prosecutor found out about this report, they should have said, hold on, we're not moving forward until we investigate what's going to happen. I'm certainly not going to go to the judge and say, yeah, I'm ready to go, if I'm not ready to go yet. Now, after this point, there were eyewitnesses, and if you read the answer and you think through what are your arguments, you could argue, yeah, okay, maybe there was not probable cause after these two pieces, but probable cause re-emerged before we went to trial. So the prosecutor's going to argue, yeah, well, I ultimately had probable cause. The problem, of course, is that the prosecutor's duty is not just to proceed with the case toward guilt, but it's to protect the potential for innocence as well. And so it was improper to keep going no matter what. There was a duty to kind of take a pause here. That's what you need to show in your answer, is the duty to take that pause because the prosecutor has a duty to always proceed in good faith based on probable cause. That's this analysis. Now here, candor before the court, just keep it really simple. No attorney is allowed to make a false statement before the court. So what was the false statement? Well, the prosecutor says, I'm ready to proceed, but that was right after she found out that there was a report that invalidated the original probable cause. So this was a lie. She wasn't ready to proceed. She didn't find out about the eyewitnesses until the next day. So this was a lie. I think that was a pretty simple sort of reading comprehension aspect of the analysis. Now, this I think is interesting, and you should pay attention to with some detail here. Okay, the rule is that a prosecutor has a duty to reveal material exculpatory evidence. Now, that's an important point because in this analysis, the entire analysis hinged on, do you understand what material is versus non-material? Now, you could have just done an analysis based on the duty to reveal exculpatory evidence, right, which was this report, but if you were able to pick out that there's an argument about whether it's material or not, that's a whole other level of analysis. And that's what happened in the published answer. So what does it mean, material exculpatory evidence? It means that the evidence is of such weight that if it's not presented to defense counsel, it's going to prejudice the case against the defendant. Whereas if it was presented to the defense counsel, the entire case could have been different, meaning the guy might not have been guilty. All right, so that's the notion of materiality in this context. So what was the evidence? It was the federal agency report. I love the way the guy, whoever, it could have been a gal, a guy, whoever wrote this answer, I love the way they did it because the federal agency report was exculpatory evidence and it should have been revealed to the defendant, except for one thing. Is it really material? Does it really matter if the case is going to hinge on these eyewitnesses? Does it really matter that the original forensics were not worthy? Probably not, and you saw the argument. However, on the flip side, which I thought was really brilliantly expressed, is the fact that, well, if they screwed up here, if the police screwed up their investigation here, well, then maybe they screwed up their investigation over here as well. And so those facts hinging around the materiality, that shows real comprehension of this legal principle and a real comprehension of the facts that are being presented, that were presented. Communication with the judge. Well, you'll see, is there 5 big issues? It's typical of a professional responsibility question. There's usually 5 or 6 issues. So here we go. You're probably running out of time. Keep it simple. What's the issue with communicating with a judge? Well, the prosecutor has a duty to seek justice, which means go after someone who's probably guilty, but also protect someone who's potentially innocent. Well, look, this person, there's some controversy as to whether or not this person may have a good defense. Now, the prosecutor comes to the judge and says, "Yeah, I'm ready to go," but he does so in front of the judge without counsel present. So it looks like, what is the prosecutor doing this for? Probably to influence the judge to sort of not worry about the fact that there was some other ethical problems and we're just going to go through with it anyway. Make sense? So that is the analysis of this question as a whole. And I think the key for you is to recognize where were the places where you could argue the facts in each of these major areas. And maybe that's like no kidding, but that is what you always want to look at. You want to have simple rules, complex facts, right? Because all the points are in that thick analysis.